Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. And remember that if the panel has additional questions past the time you've been allotted, we will ask them and you'll have a chance to answer. We have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you represent and how much time you are requesting. People versus Acosta. Submitted. Carrasquillo v. 303 West 102nd Street. Do you want time for rebuttal? Do you want time for rebuttal? Give you 4 and 1? He asked for 5. I'll give you 4 and 1. 4 and 1 and 5. C. Shania is submitted. Elmaz v. CNY Construction. Four minutes, okay. 4 and 2 and 2. Excuse me, 4 and 2 and 4. Thank you. On People v. De La Cruz, Justice Rosado is recused. Who's here for De La Cruz? Submitted. Blumenfeld v. Smith. You want 7? I gave you 3 and 1 and 3. 3 and 1 and 3. Ermina v. 2050 Valentine Avenue. You want time and rebuttal, appellant? Okay, I'll give you 4 and 1 and 5. 721 Bauer v. Premier Digital. Looks like you don't have an opponent. Do you want to address the panel anyway, counsel? Your call. I'll give you 2 minutes if you want. 2. People v. Raheem Grant. Submitted. Carbon Direct Fund v. Lanzatech Global. 5 and 2 and 5. Lackwood v. Lackwood. I'll give you 5 and 2 and 5. Nahara Adornias v. 260 Partners LP.
For appellant 4 and 2, please, Your Honor.
Your Honor, for respondents,
4 and 2 and 5. People v. Tiara Richards. I'm sorry, counsel. 5 and 2 and 5. Wells Fargo Bank v. Iqbal. Submitted. Yates v. City of New York.
Respondent 5, Your Honor.
4 and 2 and 5. People v. Joshua Soto. 4 and 2 and 4. People v. Anthony Thompson. Submitted. Tang v. New York City Transit is submitted. First case up is Carrasquillo v. 303 West 122nd. Ready, counsel? Yes. Go ahead.
Good afternoon. If it pleases the court, our position is simple. The Supreme Court didn't consider all of the attendant circumstances nor place appropriate weight on preservation of the status quo regarding issuance of the preliminary injunction.
But counsel, you take issue with the argument that each element for preliminary injunction must be satisfied?
Yes, and it's our position that the appellant did satisfy each element of the preliminary injunction. However, we also believe that greater weight should have been placed on preservation of the status quo as well as irreparable imminent harm based on the fact that she's looking at dispossession from her home as well as loss of her life's investment based on numbers and issues that really remain in dispute. So if the purpose is to preserve the status quo pending final resolution on the merits, and the merits haven't been determined, and there's significant dispute over whether or not the calculation of arrears was correct, the court didn't take appropriate notice of the prolonged violation history and placed dispositive weight on a singular issue of lack of cooking gas in the apartment.
Now, was a stove provided by the landlord at all?
I don't
Either
know if it
electric
was
or gas.
I know the appellant ultimately purchased her own stove. It was an electric stove, so the issue of cooking gas was never resolved. At least the provision of cooking gas was never resolved.
Was there an attempt to resolve that issue, the cooking gas issue?
There was an action in civil court in the HP part where civil court issued an order requiring that to be resolved after dispute over whether or not the appellant provided access or whether the respondent was able to actually remedy and perform. There was an issue over removal of cabinets and an exhaust fan in the kitchen, which appellant, as an ordinary citizen, is not really in a position to do. And so the ultimate resolution was to provide, or for the appellant to provide her own stove, and she purchased an electric stove. But you have a history of 29 HPD violations going back over several years, not least of which was...
Counsel, is the stove still in play? Are you making an argument that the stove is a breach of warranty of habitability that would give rise to some claim or not?
No, actually, that's not the dispositive issue. The dispositive issue was the fact that there was a question of whether or not there might have been an entitlement to an abatement of the maintenance over the years of issues within the unit, as well as the issue over whether or not the respondent properly withheld the shares upon satisfaction of the note. The respondent claimed that the principal was paid and satisfied on the note, but the interest...
Did you make that argument below, though, counsel, or did you make that argument about the shares below?
I didn't handle it in Supreme Court.
Was it made below?
I believe it was made below, or at least, if it wasn't made below, it was in the record. So it was presented to the Nisi Prius court. Whether or not that argument was made, I can't speak for prior counsel, but it's certainly an argument that I'm making, that there's a question over whether or not the...
But it's not a purely legal argument. It's also, it's intertwined with the facts, I think.
It is, but I'm not injecting any new facts into the record, and so I'm making the argument, I made the argument for the first time on appeal, whereas prior counsel didn't. But ultimately, there are issues that are in dispute with regard to the actual proper calculation of the arrears and whether or not the note was satisfied such that the respondent didn't release the shares back to, I'm sorry, I believe my...
You can finish your thought.
So the respondent didn't release the shares back to the appellant, which would warrant depositing the maintenance in escrow, and the idea that the merits weren't resolved prior to rejection or refusal to issue the preliminary injunction is what the issue is. It's greater than just the singular issue of lack of cooking gas in the apartment.
Thank you, counsel. You have time in rebuttal.
May it please the court, Eric Lanter of Offit Kerman for the respondents. I'd like to pick up on the issue of the status quo because I think it's one issue that the parties have disagreed on the papers, but it's actually quite clear that...
Counsel, before you get into the status quo, was she provided with a stove in addition to the one that she bought?
So my understanding from the HP case is she was offered a stove and she rejected it on the basis of a lack of trust with the HDFC.
Did she allow access to set up the gas for the stove?
I believe that was an issue. I believe she did not allow access, and there's an affidavit that was submitted to the Supreme Court detailing some of the issues. There's obviously some acrimony between the parties when it comes to resolving some of those issues. As to the status quo, the shareholder is now at a place where she's a former shareholder. The notice to cure time was 10 days. That time lapsed. And in fact, the order to show cause seeking an injunctive relief wasn't filed until after the termination was completed. So appellant has made much of the fact that she thinks she may be entitled to stop the sale, which may or may not be true, but she is no longer a shareholder and is seeking in her complaint, she is only seeking two types of relief, injunctive and a declaratory judgment as to a number of claims that are sounding in breach of warranty of habitability and other such claims. Another key point that I think that just fundamentally on the papers there was some disagreement about, but I think it is very clear, is the concept of irreparable injury. The UCC invariably applies to these shares, and the fact is there is an adequate remedy at law that exists, right? The UCC contemplates that shareholders may have issues with...
You proceeded under the lease, not under the note, correct?
That is correct, Your Honor.
So let's talk about, if you're proceeding under the lease, what are her remedies?
Under the lease, so just to be clear, from respondent's standpoint, the security agreement that the shareholder entered into opened her up to having a number of remedies she doesn't have under the UCC. The proprietary lease confines her to what remedies are available under the UCC, and that's what brings New York UCC 9-625B into play and mandates that monetary damages are sufficient and in fact required, as the second department has held, to make her whole again. If the key distinction being, if she had brought her application for an injunctive relief while the cure period was still open, that would have extended the cure period, allowed her to then take the steps to in fact cure, and then enable her to ultimately keep her shares, because she would have staved off the termination. Because she didn't do that, that is ultimately the distinguishing factor. And in one of the cases we cite, CASPE, which is an appellate division case, touches on that fact. And that is the key distinction, because the timing of that is what makes the difference between...
Counsel, isn't it true that the loss of one's apartment is much more than monetary damages, and that comes within the rubric of irreparable harm?
Your Honor, that would be true, although that's not the case here. This is not a case... First of all, appellant is the plaintiff, and she is seeking a declaratory judgment injunctive relief. She is not subject to any sort of eviction proceeding or anything that's going to immediately
A foreclosure of the lien means that she has the loss of her apartment. Isn't that irreparable harm?
The loss of her shares, rather her shares being sold to a new purchaser, then opens her up to the potential for an eviction. In fact, that there's a likelihood of eviction, of course, but that's not what the issue, that's not the juncture at which she is in this case, where it is now post-termination and she has no ability, she has no right to the shares of the apartment any longer. Finally, I just want to touch on the likelihood of success on the merits and just reemphasize the fact that there are several causes of action identified in the complaint, but the only relief sought is injunctive relief and a declaratory judgment. The evidence submitted, I see I'm out of time.
No, go ahead and finish the thought, counsel.
Thank you. The evidence submitted by the appellant indicates that there were some payments made towards the arrears, and now those arrears may be maintenance or they may be part of that loan that the HDFC extended to the shareholder, but regardless of that, there is not sufficient proof in the record to show that she paid the arrears in their entirety.
Thank you, counsel.
Thank you.
You got 1 minute.
Thank you, Your Honor. So with regard to the notice to cure, the irreparable harm that the appellant would face from dispossession and loss of her investment, to so rigidly predicate this case on the fact that, well, the appellant didn't act in time or didn't respond to the notice to cure in time, really shouldn't be dispositive in determining the overall severity of the circumstances that the appellant faces. Additionally,
Counsel, don't the balance of equities go both ways here? Because this is HDFC, which is a low-income co-op, and they often have problems with payment. People making their maintenance on time. So how do the equities balance out here? She's losing her apartment, but they are often, in financial precarity.
Understood, but simultaneously, the appellant, first of all, she satisfied the terms of the note, but more importantly, she made the maintenance payments up and through 2022 when the respondent commenced rejection of those payments. Additionally, the amount that they're claiming that she owes is in dispute, and the notice didn't provide a commencement date on the date that the arrears began to accrue, so she couldn't cross-reference her records. They just gave her a number up and through an end date and said, this is what you owe, when in fact, several of those months that were within that calculation may have already been remitted. So the idea that the HDFC is operating on a shoestring budget and they're strapped for cash shouldn't necessarily be the dispositive issue in balancing the equities with respect to the appellant's situation.
Thank you, counsel. Thank you both.
Thank you very much.
Elmaz v. CNY Construction. Please.
Thank you. May it please the court. Laura Parkman for the plaintiff appellant. In this case, the plaintiff was holding a ladder which was leaned against the wall while his coworker was installing cables in the ceiling and...
Yeah, we're pretty familiar with the facts, but
Right.
there's quite a discrepancy in the height of the ladder. Does that matter?
I'm sorry.
There's quite a discrepancy in the record about the height of the ladder, whether it was 30 feet or whether it was,
That's
it had 12 rungs, and so people infer that that means it's an 8 to 10-foot ladder. Does that discrepancy in height create an issue of tribal fact?
not at all, Your Honor. They try to raise a bunch of issues which are not at all material. The height of the ladder, the exact height of the ladder being one. Whether the ladder was 30 feet tall or 10 to 12 feet tall, it was still a height differential, a significant height differential where his coworker was working above him and a falling object fell on him due to gravity. So one of the things the court found was that, oh,
I'm not sure what just happened.
that can't be right. Should I continue?
You have 3 minutes left.
One of the things the court found was that the plaintiff didn't establish that it wasn't an ordinary danger. We say this is a quintessential falling object case. The court found that the plaintiff did not establish that the drill required to be secured or that the lack of protection was a proximate cause. We think these are clear errors, both factually and legally. The drill was required to be secured. The defendant's own witness testified that anytime overhead work is being done, everything should be secured or the area below should be vacated. And legally speaking, there's no way to distinguish this case from your court's recent case of Rincan or Rinsan, which we cite in our brief, where a coworker who was working on the roof dropped a wrench and struck the plaintiff. And this court said that plaintiff was entitled to summary judgment because the defendant failed to provide adequate safety device to protect the plaintiff from the falling object, which should have been secured. There's no difference between a wrench and the drill in this case.
Counsel, does it matter that the defendant as is argued, placed the ladder himself, leaned it against the wall after having been instructed not to use it in that fashion?
Thank you for the question, Your Honor. No, it does not matter. Even if there is an issue of fact as to who placed the ladder, there's evidence that the defendants placed it. But even if the plaintiff and his coworker placed it themselves, they did that at the express direction of the supervisor, Lewis, and that is undisputed in the record. Defendants concede on page 45 of their brief that Lewis, who was his supervisor of his employer, instructed him to hold the ladder, which was only necessary because it was leaning and not open. And it's very clear that a worker cannot be the sole proximate cause of an accident or recalcitrant if he's following the directions of his supervisor. And there's a plethora of cases from this court. There's Gove from 2013, most recently Asian from 2024, where the conduct was consistent with the employer's directions. You cannot be the sole proximate cause.
Thank you, counsel. You have time in rebuttal.
Thank you.
May it please the court, Your Honors. My name is Carol Finocchio. I am here for the defendant's respondents. It's our position that the order appealed from should be affirmed. The lower court did a well-reasoned order. The reason that the height of the ladder is important here is because incident reports done simultaneously with this accident show that there's an issue of fact as to whether that drill was on the coworker's side as he was descending a ladder from a height of 7 or 8 feet after working on feeder cables on the wall.
Does it make whether it was 10 feet or 30 feet with regards to the issue you just pointed out?
Exactly, Your Honor. My point simply is that if he was descending the ladder and the drill was on his side and it fell out, that's an ordinary hazard of construction. And I believe that that's why the lower court said that this is not necessarily a labor law 240.
Doesn't our case in Rinson contrary to what you just said?
Your Honor, I disagree with the Rinson case. I know we distinguished it in our brief.
Can you tell me how it's distinguishable? We have a wrench that falls, and here we have a drill that falls, and it was the same situation.
Your Honor,
Similar situation.
if a wrench is, if the worker was all the way up in the ceiling and the wrench fell, that might be different. But here, he wasn't actually working. If we accept the incident reports and the photographs and the testimony based upon them, Mr. Grimswold of CNY, he was descending the ladder and the drill was clipped to his side, so that would be an ordinary hazard. He wasn't actually in the process of working, and what's a scaffold going to do to prevent that? He'd still be coming down, so you can't have a scaffold if you're climbing down a ladder.
Case law is not so discreet as you say. Case law says as long as you're within the rubric of a laborer that's doing work on a project, that's sufficient. You don't have to be actually doing the work in order for the labor law to be triggered.
Well, Your Honor, my response would simply be that there are also other additional issues of fact, including who set up this ladder, who provided the ladder, and
Did Mr. Lewis tell them to, did Mr. Lewis, the supervisor, instruct the plaintiff to hold the ladder
according
as
to
stated?
plaintiff, Mr. Lewis told him to hold the ladder.
Isn't that uncontroverted?
Your Honor,
I think it's admitted, no?
Your Honor, all I can say on this record is it's not clear that it's uncontroverted. And
So where is there contrary testimony of that fact?
Your Honor, we weren't there, so
I know you weren't there, but we have a nice record. So
Right,
tell me
no,
where
I
within the
understand.
record
Your
is
Honor,
there
I
a
can't-
testimony, let me finish, please.
Oh, sure.
Where there is testimony that would contradict that fact.
Your Honor, I can't point to anything.
Thank you, I appreciate that.
Okay, Your Honors, unless there are other questions, I will rest on my brief.
Thank you.
Thank you so
Other
much.
questions? Thank you, counsel.
Thank you, Your Honors. Just quickly, Your Honor's question answered about the descending, and it doesn't have to be at the exact moment of work. Just quickly, even if he was in the process of descending, and even if it was clipped to his belt, the clip was obviously inadequate and to provide proper protection because the drill fell. And what she's talking about a scaffolding, just like in the Rinson case, something as simple as a strap or a tether, where had the drill been tethered to his coworker, it would not have fallen. The plaintiff doesn't have to say what safety device would be used, but there is a simple thing that was noted in the Rinson case with the wrench that would have prevented that. So all of these issues, they're not material issues of fact for the 240 sub 1, because regardless of whether he was in the process of descending, whether it was clipped, it's undisputed that the
Counsel, are we allowed to look at the fact that his wrist did swell and did have medical issues? Or is that somehow a tautology? In other words, you're looking at the injury, and therefore that's evidence that there was a gravity-related risk because it caused this injury. Is that something we can look at in determining whether or not this was a gravity-related risk?
I mean, sure, you can look at that. I don't think it's
you
necessary
would
at
say
all.
that.
All of the reports, all of the evidence, it's undisputed that it fell from a height when his coworker was working above on the ladder, and whether he was at the top, whether he was on his way down, it fell from the height, from a significant height differential because it wasn't secured. And that is a 240 case right there. So the court clearly erred in denying summary judgment on that claim. Thank you.
Thank you, counsel. Thank you both. Blumenfeld. Please.
Good afternoon, Your Honors. Eliad Shapiro, Herrick Feinstein for the appellants. Your Honors, the court below summarily denied the defendants here their statutory right to a bill of particulars in a case where the complaint is 355 paragraphs long.
Yeah, we know, but the bill of particulars demand is even longer. It seems to be going to great detail that normally you would use discovery devices such as EBTs or interrogatories. I agree with you that a BP is not foreclosed in a commercial case, but here it just seems that it gets in the weeds too much. So tell me why I'm wrong about that.
Well, Your Honor, if we look at the record, and I'll point the court to just an example, the complaint contains allegations concerning 14 LLCs of
Right,
misappropriation.
and each of them has,
They have,
right.
I
Okay.
apologize.
Go ahead, counsel. I know, there's repetitive claims in the complaint, for sure.
There are repetitive claims, and the complaint is bereft of any factual allegations concerning 8 of those LLCs, not a single factual allegation. The other 6 LLCs, there are only 8 allegations of specific transactions, and the plaintiffs claim that there are other unalleged inspecificities, unalleged harms. They don't tell us what they are. And if we look at the complaint, just as one example, if we go to page 42 of the record, and we'll take one paragraph, paragraph 110.
Counsel, none of this really responds to what I'm saying, that you could use other discovery devices to get at this rather than a BP.
Well, the Court of Appeals has said, for example, in Northway, that the availability of other discovery devices doesn't negate the availability of a bill of particulars. In
Are
fact,
you allowed to seek evidentiary matter through a BP demand?
but the BP demand here doesn't seek evidentiary matter, an evidentiary
I
material.
don't buy that. It's just like you're asking them to identify evidentiary material by specifying documents, including bank statements, financial statements, that support the complaint. Those are specific things that you're asking for.
So I'll respond in 2 points to that. The first is that that's in response to allegations that they make themselves in the complaint that they reviewed documents which provide specifics. And even if the court were to, so that they put those at issue. And those are allegations made in the complaint. But even in the event that the court were to take the position that that does seek evidentiary material, there are a litany of cases in this department where the court simply upholds the BOP and says that those specific demands are stricken, but upholds the rest. And the reason why it goes into details is because detail is not provided. They, for example, allege diversion of monies, but they don't say how much. Other related entities, they don't tell us which. Excessive interest charges, they don't tell us what the interest charges are for advances made by one of the defendants. They don't say what the advances are. The excessive fees, they don't tell us. I see my time.
Counsel, you have time to rebuttal.
I see my time's up.
Good afternoon, and may it please the court. Jeffrey Peters, Kurzman, Eisenberg, Corbin, and Lever for the plaintiff's respondents. I think the court in addressing my counsel was exactly correct. This is a case where they have 1,849 individual demands set forth in 551 paragraphs.
And
have us
some of it involved information that they may already have, correct?
I think all of it involves information that is in their possession. They are the managers and managing agent of all of these defendant entities. And for counsel to sit here and say that there's no allegations of fact in this complaint is simply not plausible, because the Supreme Court, as admitted in pages 3 and 4 of the opening brief by the defendant appellant, denied a motion to dismiss and said that the allegations of the complaint were sufficiently particularized under 3016B. So to say that there was only allegations against 8 of the 14 entities and there's no allegations against the other 6 simply isn't true.
Okay, with respect to identifying witnesses, which they do in the demand, they're arguing that they're just trying to figure out which allegation is attributed to which defendant. What's wrong with that?
So I think in addition to finding out which allegation is to which defendant, they're also trying to find out all other non-parties where these allegations come up with. Because, for example, there's demands which talk about monies given to various, for construction fees and various other fees, and those are all non-parties. So to identify those people, to identify witnesses with knowledge about this case. It's not simply identifying who of the defendants, because all of the defendants were involved in this pattern of misconduct in which they took monies from the nominal defendants, swept them up into the managing agent's accounts, and then loaned those monies back to the nominal defendants to cover the cost of their operations. So I think the Supreme Court was correct in saying that this demand was simply a means to torture the plaintiffs by providing money.
I guess there was some date for for the parties to provide either interrogatories or EBTs. I know a bill of particulars wasn't mentioned, but when was the first time you heard that they were going to serve you with the bill of particulars?
Until we got them.
So December 6th, or whatever the date was that you exchanged discovery?
Yes, Your Honor.
Okay.
And that's the other thing. They try to say that this is going to help them and guide them in document discovery, but it can't, because they served the bill of particulars the same times they had served document demands, and responses were all due at the same time. So there's no efficiency gained here from a bill of particulars in this case. I would just add again, I think the Supreme Court was correct in relying on Rule 11. While it doesn't guide a bill of particulars, it does in this case, because the types of questions that were asked were those that should be in commercial division interrogatories. I see that my time's up. If I could just finish one thought.
Go ahead.
That rule has specific topics that can be addressed, and a lot of these bill of particular demands address those specific topics. So to have 1,849 individual demands to address what could have been only 25 makes this a grave deficiency on this.
Thank you, counsel.
Thank you.
Your Honors, just a few brief points. Your Honor said that we have all the information, but that's not
I
true.
didn't say all.
Oh, you said we have a lot of the information.
Yes.
But we don't. The point of the bill of particulars is for the plaintiffs to specify that which they have the burden of proving. They make allegations, but we don't know what the allegations are. Over half of the LLCs that they claim there was misappropriation of monies and there were other misconduct, we don't know what those allegations are. So while we may have discovery, we don't know what we're litigating about. We don't know what we're trying the case about. That's the issue that we have and why we ask for the demand of bill of particulars.
Counsel, is that a slight overstatement? I mean, you do know that they say that the defendants misappropriated funds, that Samco is the instrument of some of that misappropriation. I mean, you can't say you don't know anything from this complaint. It's
the plaintiffs do allege 8 transactions.
Also, and just another
Apologies.
thing, there was a motion to dismiss, right?
And
What
that's up on appeal for the next term.
But it was denied.
The motion was denied, yes, which is why we served the demand for bill of particulars. That's why we're here. But that appeal is up for the next term. If I can just finish the thought.
Sure.
Your Honor, Rule 11, you are correct. The Rule 11A does not apply to a demand for bill of particulars by its terms, and that the point I just want to stress is that There are a lot of demands. There are obviously a lot of demands. It's because the complaint is such a sprawling length, and in that length just does not manage to allege factual allegations, which this court has held time and time again in cases like Malin, Netter, Penn, Texas, Golden, and then the Second Department in Singh, in Gorbatov, where you don't have the specifics that you need in order to prevent surprise at trial and limit the proof. The proper remedy is a demand for bill of particulars. If the demand is long, it is only because the complaint is at such a sprawling length.
You do make that point in your papers, counsel. Thank you.
Thank you, Your Honors.
Thank you both. Ermina v. 2050 Valentine Avenue. Counsel? Please.
Good afternoon. May it please the court. I am Luis Guerrero, and I'm the attorney for the plaintiff appellant, Daniel Hermina. This appeal concerns whether CPLR 205A bars, and 205A being a remedial statute, bars a timely filed negligence action when it was filed within the 3-year statute of limitations.
I read defendants to say that they concede that 205A does not apply.
I read that too.
Okay.
Didn't they say that? Yeah, so you can move on to the next.
Okay. So at the end of the day, they used 205 in the order, the lower court, to find that the last dismissal, the original dismissal, was based on a neglect to prosecute, and therefore that 205 prevents the second action from being commenced.
Well, Supreme Court found, go ahead, please.
No, go ahead.
Supreme Court found that its initial decision was with prejudice, although it doesn't have those words in it, right?
Right. The words are not in it.
He dismissed without opposition, but he didn't say anything about prejudice, correct?
Right. He said nothing about prejudice, said nothing about willful neglect, said nothing about a pattern of delay, made no factual determinations, didn't say anything about an intent to abandon, didn't say it was on the merits or there was a neglect to prosecute or with prejudice under 3216. Not to mention the fact that 3216, the very last sentence of 3216A, specifically reads, unless the order specifies otherwise, the dismissal is not on the merits. So at the end of the day, the action was timely commenced and should be reinstated. The second issue is that the neglect to prosecute wasn't documented in the underlying decision, but in the second dismissal order, the court actually went through an itemization of what the neglect was. But that's in violation of CPLR 5019, where he's trying to sort of correct the prior order in the second dismissal order by providing the factual determinations regarding the alleged neglect to prosecute. Not to mention the fact that I cited several cases from this court and the second department that all hold the same thing, that CPLR can't be used as a weapon to preclude a second action, especially when second action was timely commenced within the 3-year statute of limitations. I don't think that defendant respondent bothered to distinguish or provide any other case law to the contrary, and to argue that CPLR 205A somehow shortens the 3-year statute of limitation is not found anywhere in the law or the case law. I also wanted to note for the court that the underlying case that was dismissed was based on, in essence, on a motion, a 3216 motion for want of prosecution. That was the first action. And that motion was jurisdictionally defective because they never served the 90-day demand. They didn't comply with the time restrictions in 3216 and filed their motion prematurely. In the brief that I submitted, I think it's about 4 months premature in order to meet the timeline of 3216. And that's
We don't even need to reach that, though, counsel, if we agree with you on the other points, right?
I agree.
Okay, thank you. You have time to rebuttal if you want it.
Afternoon, Your Honors. May it please the court, we represent the defendant's respondents.
Counsel, put the microphone a little closer.
Yeah, I'm sorry, appreciate it. Well, first of all, Your Honors, the initial the 22 action, where the decision was made in December of 2023, the record is clear. There was no appeal filed in that action. There were no opposition papers filed on our motion to dismiss by plaintiff.
But counsel,
Yeah.
first of all, you can see 205A does not apply.
Yeah.
Second thing is, whether or not they appeal that is irrelevant because they filed a new action,
Yes. I will get to that, Your Honor.
right? And the previous action, according to the court's very own decision, was not dismissed with prejudice, and it was not on the merits. So they were perfectly entitled to file the second action, weren't they?
Yes. Well, the thing is, Your Honor, Judge, the Honorable Raymond Fernandez, in his decision in the second action, he lays out exactly why he made the decision in the first action.
But that's
But
not
that
the way it
doesn't
works. That's not the way it works. Because when he decided when he granted judgment and dismissed the first action, that's where he should have laid out the reasoning for dismissing that action. You can't do it in a subsequent action that was timely commenced.
Well, Your Honor, the reason that decision was even made in the first action was due to the general, that action had been going on for 4 years, Your Honor. There had been no discovery.
Understood, but that's not what his decision says.
Yeah. That case was dismissed. Our position is this, in this matter, the claim is disbarred because under res judicata.
But how does res judicata applied
Because,
when the decision was not on the merits?
Because the first position, our position, the first position was dismissed under the basis of neglect to prosecute.
He didn't include that in his decision. He
In the
said
initial-
dismissed without opposition.
in the
He
ini-
didn't say for neglect to prosecute. He didn't say with prejudice. That was in 2023. He can't fix that in an order in 2025.
That is what pertaining to this action, Your Honor. It's there's a lot going on in this action, Your Honor. There's been no discovery exchange. There's issues with appellant's argument that there was no 90-day demand notice. The Supreme Court has inherent discretion to dismiss an action based on the fact that there's been no discovery been made, and that is stated in Andrea Villarnone.
I agree with you that they can do that.
Yeah.
But this is what the court's decision says. And I'm going to read it to you
Yeah.
because I have it right here. And it appears in the record at page 48. And it says, upon the foregoing papers, the instant motion is granted without opposition. Accordingly, it is hereby ordered that the motion is granted, and the clerk is directed to dismiss the complaint and enter judgment in favor of the defendants.
Yeah.
That's it. Nothing about with prejudice, nothing about on the merits. There's nothing.
Well, Your Honor, with respect to this action, when we filed our motion, we laid out exactly what had been happening in the history of this case, including in 2022 and in 2024. Nothing has changed in terms of the fact that we have received no discovery in this matter.
This is a new
And
action.
then we filed, and then
This is a new action. Move to dismiss and move to dismiss with prejudice.
And in this new action, when we filed that motion, and when the Honorable Judge Fernandez granted the decision, he understood exactly what had been going on in this case, including in this matter, where I don't believe we have any discovery on this matter.
Counsel, we would agree, and we wouldn't be here if he has said on the merits with prejudice for failure to prosecute.
He does say that in the decision.
In the second decision, 2 years later,
Yeah.
In a new action.
Yeah, and in the new action, which, by the way, the plaintiff did nothing so once the first decision was made, plaintiff did not file an appeal, they did not oppose. About 2 years later is when the second action was filed.
But it was timely.
It
Cannot deny that it was timely. They still have a couple of days. He still had a
days,
couple of days left on the statute.
Yeah, and that is our position, Your Honor. There's just a lot of issues with respect to how the plaintiff has been going about with this case and dealing with us, and it is our position that Judge Fernandez's decision was accurately and appropriately given, and I would say public policy also dictates that we made over 12 good faith correspondence attempts, efforts to conduct discovery, and I see that my time is up, but I mean,
Thank you, counsel.
yeah, sure.
Quickly, I just wanted to note that he referred to the dismissal of the first action. And in that action, I filed a motion to vacate, which the judge also denied, and I filed a notice of appeal to the motion to vacate, which, depending how this appeal goes, I will probably vacate and withdraw if the appeal goes our way. When it comes to public policy, I think the clear policy in this state is to decide cases on the merits and not have them dismissed on procedural grounds. And so I think the plaintiff appellant also should prevail on that argument because, again, he should have his day in court on the merits and let the case be adjudicated completely. Thank you very much.
Thank you, counsel. Thank you both. Uh, 721 borrower.
Good afternoon, Your Honors. Charles Bulbul for the plaintiff appellant, 721 Borrower LLC. The counterclaims that the court sustained are based upon the same facts that were the basis for the dismissed affirmative defenses. Documentary evidence clearly bars the affirmative.
You definitely have an argument on that based on what Judge Leibovitz said, but he didn't. He went out of his way to not dismiss the counterclaims, though, because he said you didn't add any substantive argument.
Well, as pointed out, I believe on page 3 of my brief, I quoted directly from the Cohen affirmation in support of the motion for summary judgment, which laid out why the counterclaims were without merit. Also, our reply to counterclaims is verified, which likewise qualifies as an affidavit. And that was before Justice Leibovitz at the same time. And on their
Wait a minute,
face,
the reply was, I missed that part of the record.
verified reply to counterclaims.
But is it a brief or is it an affirmation or?
Well, it was attached to the motion papers
It's motion papers.
for the motion for summary judgment.
Somebody signed it, obviously.
Oh, yes.
But no one swore to it or affirmed to it.
Yes, they were.
Oh, I'm sorry. I
Oh,
missed
yeah,
that.
they were.
I'll have
The
a look.
reply to counterclaims was affirmed, yes. And also specifically in the Cohen affirmation, it went line by line through why the counterclaims were without merits. And on their face, the counterclaims, if they exist at all, which we submit they don't, belong only to the tenant. I would just note for the record that this panel in the, actually Justice Hagler in the 75 Broad case that I cited years ago says that a guarantor can't use tenant defenses. That's exactly what was sustained here.
I agree with you there. And then also the guarantee is very broad. So it seems like against the guarantors, they can't have counterclaims.
It's impossible. And with respect to the tenant, they waived in the stipulation, the August 2020.
They only waived affirmative defenses. They didn't waive counterclaims.
But again,
Am I splitting hairs?
the court ruled that the exact same facts
Yeah,
were
but then he
barred
didn't
by the
dismiss the
provisions
counterclaims.
of the lease.
The only,
I understand your Honor's point, and I
kind of a
don't
little
disagree
opaque.
with that as a technical matter. But for the tenant to say the elevator doesn't work, the lease says specifically, if the elevator doesn't work, you have no remedy.
please.
So I just want to make this perfectly clear. In your notice of motion, did you move to dismiss the counterclaims?
We did, yes, we did, Your Honor.
In the Cohen affidavit,
Off the top of my head, I believe it was paragraph 48 of the Cohen affirmation.
that's exactly what I was pointing to. So paragraphs 48, 49, 50, and 51. Is that what you're referring to?
That is what I'm
That's what I
referring to.
Any other questions?
Nope.
Thank you,
Your
Counsel.
Honor.
Okay. Carbon Direct Fund v. Lanzatech. Please.
Good afternoon, Your Honor. Owen Roberts of Quinn Emanuel, Urquhart, and Sullivan on behalf of Appellant Carbon Direct Fund 2 Blocker 1 LLC. Supreme Court erred in this case by ruling at the pleading stage that the only reasonable interpretation of this contract, and specifically the definition section, Section 8F, was one that gave the borrower unbridled discretion over what kind of equity to convert my client's debt into.
Where in the note does it say that anyone else has any discretion to convert the note to either common stock or preferred stock?
So if I understand your Honor's question correctly, there's no place where it grants discretion over the choice. It identifies any party that has discretion over the choice of what kind of equity to convert. It is dictated by the formula, and we know that because the formula uses the price of one particular type of equity to determine how much conversion equity to issue, something that would only make sense if there was a linkage between that input and that output. We also know that because throughout the contract, in many different sections, where the parties intended to give one party discretion to make a choice, they did so expressly. And they certainly did not do so in Section 8F. It does not say Lanzatech may issue common shares or preferred shares, just as it does not say that my client may demand common shares or preferred shares.
Yeah, but you have the definition section, 8F rather. Conversion shares mean shares of common stock or convertible preferred stock of the company. That's what you got to get around. And I gather you're trying to use paragraph 4A to do that by saying, as the case may be, somehow it modifies that. Is that correct?
I don't believe it modifies Section 8F. What Section 8F says is it will be one of those two forms, and it does not give either party discretion to make that choice. Instead, it gives the flexibility to match the type of preferred or common equity that was raised.
But if that's what you meant, that's what you should have written.
And I believe that they did write that, Your Honor.
Where?
They wrote that in Section 4A by saying that what is going to happen here, the conversion formula that is going to be followed, is based on the price of the qualified equity financing.
It may say that, but you're forgetting the link that you want us to read into it, which is then the stock has to match.
So I'm not. I believe that that is by far the most natural interpretation of the way that this contract is set up. We are here on a motion to dismiss. The only question is whether there is any reasonable interpretation that does require that type of matching. And by the same exact token, if this was a place where the parties wanted to give one party discretion over this fundamental question, they would have done so, because they have done so throughout the contract where one party has discretion. So the idea that this contract could have been written in a way that clarifies this question.
So, counsel, are you arguing that the definition section, which defines shares of common stock or convertible preferred stock in a disjunctive way, is as ambiguous or unambiguous?
It is at worst ambiguous. It is certainly not.
What makes that ambiguous? Because I can read that clearly. They have either to give the common stock or the preferred stock.
So the way that New York courts have interpreted exactly this word, and in a authority cited by Lanzatech, the Heard v. Kelly decision, used very similar phrasing. It said, this note will be payable on January 1st, 1883, or within 6 months of demand. And the borrower said, I get to choose which of those two I'm going to fall into. There's a word or, it's disjunctive, I have the choice. And the Court of Appeals rejected that interpretation and said, look at the overall circumstances, look at what they're trying to accomplish. The or is not disjunctive in a way that gives choice to any party.
Can you tell me that case again? I didn't hear you clearly.
Of course. Heard v. Kelly, 78, New York, 588. And again, that is a loan where the borrower is looking to an or and says, well, it's disjunctive, that gives me a choice. I have not seen in any briefing in this entire case any decision that comes out that way, any decision that says, here is a contract that uses an or, that gives one of the two parties discretion to choose. And if it does give the parties discretion to choose, it certainly does not identify which party has the discretion to choose.
Let me ask you this.
Yes, sir.
You have, within the note, a reservation of shares.
Yes, Your Honor.
And that reservation of shares only calls for the reservation of common stock.
That's right.
To be convertible to be convertible shares, correct?
Not to be convertible, to be conversion shares.
Yes,
sir.
to be conversion shares. Is there anywhere in the note where you also are required to reserve preferred stock to be conversion shares?
There is nowhere in the note that requires that, but just as a contract that sometimes required you to provide beef and sometimes required you to provide chicken might require you to always have enough beef on hand, that does not follow that you're never required to provide chicken.
So the contract is silent as to whether or not there should be a reserve for preferred stock in the event that you need to convert preferred stock.
That's correct, Your Honor.
Okay.
You have time to rebuttal, counsel.
Thank you.
Thank you.
It please the court, Craig Waldman for the respondents. Your Honors, the contract here is simple and unambiguous and was negotiated by sophisticated parties. The conversion feature of the convertible note is unambiguous, as the Supreme Court found. Simply stated, when defendant Lanzatech raised $40 million in equity proceeds, which was the minimum target that the plaintiff and defendant agreed upon in the convertible
Everyone agrees
note.
the triggering event happened. The qualified equity financing, it happened. They don't disagree with that.
That's right. And so once it happened, the plaintiff's note would automatically convert to debt to equity, from debt to equity, and that equity would be either common or preferred stock.
Now, as the case may be, in paragraph 4A, what does that mean then?
That's a definitional section talking about a formula that was applied in the conversion. The issue is the conversion shares is defined in the contract in 8F, and it's defined as either common or preferred. As Your Honor pointed out, the only stock the company was required to have on hand was common stock. That was the stock that the company had on hand at the conversion, and that's what the debt was converted into.
Had they had preferred stock on hand, would they have then been required to convert preferred stock as opposed to common stock?
No, Your Honor. They would
Why
have
not?
still, because they still would have had the option. 8F gives them the option to convert into common or to preferred.
So when do you convert to preferred stock, if ever?
If the company had elected for any reason to have issued preferred stock, it could have made that election. In this instance, it wasn't necessary. The only stock that they had on hand was common stock, and the conversion feature allowed them to convert into common. So that's what they did.
So it doesn't matter that they actually sold preferred stock and raised $40 million and then converted that $40 million that they had been previously loaned into common stock that was worth a lot less.
That's right. It does not in this instance matter. And if the parties had intended, as Your Honor has suggested, that it be converted into the same stock, they would have done a lot of different things in the agreement. One, they would have said that in the agreement. They would have said it has to be the same type of stock. They very expressly did not do that.
What about the phrase as has been alluded, as the case may be?
As the case may be, just defines what a type of transaction is, but it does not negate in any way or make any reference to the conversion shares. The conversion shares can be either common or preferred stock.
At the option of the company.
At the option of the company. And again, had the parties intended for something different, they would have said that, or they could have had a different formula, and the different formula would have provided for it to be the same type of shares.
Does the agreement have any provision for the event where the company had to convert to preferred stock, but they didn't have preferred stock?
That circumstance isn't contemplated because the company is required to have on hand enough common stock in the event of a conversion. So that's the protection that plaintiffs negotiated for themselves. They wanted to make sure we had enough stock.
So, counsel, you heard your learned counsel talk about the Kelly case, which refers to looking at the agreement as a whole to make it all come together rather than zeroing on one, because otherwise you do injury to one side. Obviously, the intent may have been that if the trigger event occurs, that it would be contingent upon the same preferred stock, because otherwise, why would you pay $40 million and get back 7 or 8?
Yeah, I think, Your Honor, the fairness of the transaction is not what the court below considered or needs to consider here.
I'm not really asking that. I'm really asking the legal question, whether or not we should look at it holistically rather than looking at it in a provision by provision basis.
Well, I think even if you look at the contract holistically, and I think the court below did look at it holistically, all of the provisions that we've just talked about in 4, in 7, and 8 all point to the company's discretion.
Can you distinguish Kelly? Do you know the Kelly case?
I do know the Kelly case, but
Distinguish it, please.
that's the Kelly that's Hurd versus Kelly. The only reason that the Court of Appeals in Hurd held that the borrowers did not have discretion on how to satisfy a disjunctive obligation is because the instrument at issue included language shifting that discretion to the lender. The rest of that case and all of its language supports the Supreme Court, which suggests the general rule is that when a condition of an obligation is in the disjunctive, it may be discharged by the performance of either of the enumerated acts at the election of the obligor. That's what happened here. That case is actually supportive of respondents, not of appellants.
Thank you, counsel.
Thank you, Your Honor.
So, Justice Hagler, your question shows why reversal is required here. Obviously, the intent may have been, we would say clearly was, but at minimum may have been that there should be a linkage between the type of equity that is used to price the conversion and the type of equities that is issued as a result of the conversion.
Maybe that's what you intended. Maybe that's what even I go as far as maybe that's what it should have been, but that's not what you wrote.
I disagree, Your Honor, respectfully. I do believe that
It's clear as day.
I hear, Your Honor. I respectfully disagree. It is not clear. There is not anything in this contract that gives Lanzatech the discretion as opposed to my client the discretion. It is completely silent on that question. If Section 8F grants discretion, it does not say in whom that discretion is vested. There is not a single case that has been cited to Your Honors that has ever held that an or in a contract like this gives one of the parties discretion. If that was a principle of law that could be read on a motion to dismiss that was unambiguous, then there would be plethora. We've been doing contract cases in New York for quite a while. The fact that there is no decision coming out that way shows that at minimum we have adopted a reasonable interpretation of this language and should be permitted to go forward with it. Again, that's only, I love being a lawyer, but only lawyers could sit here and say that there is no question that what this contract means is that a $40 million loan could be converted to $7 million of common equity 10 months later. There is no...
Talk about another way to get where you want to go, I think, is the implied covenant cause of action. So talk about that for a minute.
Yes, Your Honor. So at minimum...
you have to say it's not duplicative. You got to say it's not contrary to the actual terms of the contract, and that's a heavy lift. So tell me about that.
Always is, Your Honor. The reason it's not duplicative is for the same reason that I believe it was 2 years ago in the AEA versus Marblegate case was ruled to be not duplicative, which is that where there is both an allegation of, and I'll finish this thought with Your Honor's indulgence.
Please, no, go ahead.
Where there's an allegation both of a mechanical breach of contract and specific allegations in the complaint that this was a bad faith scheme to make this arrangement, then those are deemed not duplicative at the pleading stage. And that's exactly what we have at paragraphs 39 through 43 of our complaint. This is not simply a normal breach of contract where we disagree about how this was mechanically done. The purchaser who came in told my client, I am doing this to impair your note. And that cannot be ignored, and that is not duplicative of anything in the breach of contract action. That goes straight to the implied covenant breach.
All right, thank you. Thank you both.
Thank you very much, Your Honor.
The briefs in this case were excellent by both sides.
Thank you, Your Honor. Thank you, Your Honor.
Lackwood v. Lackwood. Okay, thank you, Mr. Lackwood. You may start.
May it please the court. My name is Michael Lackwood. I appear before you today pro se, not by tactical choice, but from financial incapacity after an interim pendente lite order wiped me out. The order required 161% of my documented income, not available income, but documented income. We were in a negative cash flow before divorce proceedings. I have paid my I have not paid my income tax since mid-2024. I'm the documented primary caregiver of our 7-year-old son, Lucas, who is now facing school expulsion and housing foreclosure. I come here to ask a narrower question. Do New York's mandatory marital statutes still mean what they say? When shall becomes may, the statute loses its meaning. Discretion has limits. Ignoring mandatory statutes crosses them. First, DRL 241-B shall determine income using the most recently filed tax return. My 2023 tax return of $198,000 was submitted to the court, but the court relied on my 2022 instead, itself labeled temporary and aberrational because of a one-time $175,000 insurance payout, which has never happened again. Second,
The court acknowledged that, I think, that it was anomalous to a degree. But the court also found that both sides had not been totally forthcoming with respect to their annual income. I know you disagree with that, but the court did find that, right?
I do. I understand that part, but that's my income. I submitted my expenses. My respondent is an enrolled agent, licensed enrolled agent with the IRS. We're working for a Big Four. She, just a little context, enrolled agent is the highest license that you can have with the IRS. And she's been in the business for 20 years. That tax return, just like Laporte v. Laporte, it's submitted, it hasn't been audited, we have never been audited. So statements were very truthful. If anything, the write-offs on my business has been consistent throughout from 2020, 21, 22, 23 and beyond. If DRL 236B4, the statement of net worth, I want to address this carefully, Your Honors, because opposition will argue the court read almost 100 documents. A genuine analysis would have surfaced multiple fundamental problems. One, the court treated $321,000 in gross business revenue as net personal income. That's a $123,000 error. Two, respondent put zero income on the statement of net worth, but listed $33,000 in monthly expenses. That's $390,000 gap that was unexplained and never questioned. We averaged an income of about $200,000. Dual income. Three, the court overlooked more than $500,000 in household liabilities that were put on the statement of net worth, including IRS debt that we haven't created a payment plan. Those liabilities, except for the federal and state taxes, carried a monthly obligation exceeding $10,000 a month. Four, the court assumed my combined federal, state, city, and local tax rate was just 12%. My actual rate is about 35%, which compounded every subsequent calculation. Five, the court never examined the $600,000 in fire insurance that we received from the end of 2022 to the middle of 2023. The only party who hid financial reality was the party who left six-figure tax debt off of their statement of net worth. We had two. I had a forensic accountant, respondent had theirs. Both came up with a shortfall of me being able to meet any of our bills, much less the order itself. They found a minimum of a $63,000 annual deficit. May I finish the thought?
You may.
Thank you, Your Honor. $63,000 annual deficit.
I thought you found a negative cash flow of $28,000. That was per month?
Sorry?
Your accountant found a negative cash flow for you of $28K?
Yes, Your Honor.
Was that for annually or?
Annually.
Annually, okay.
No. Month. Monthly. The deficit,
I'll
the
check.
deficit what totaled to $470,000 if you add obligations like credit cards.
You have time on rebuttal, Mr. Lockwood, but let me just say one thing. In your brief, there's a couple of cases that, I'm not going to say this, but it looks like you may have used AI to do your legal research, and you always have to check. And that's true for lawyers or for people appearing pro se. You have to check the authority to make sure it says what it says and that the actual case appears where we want to find it. So I'm just telling you that because if you continue to represent yourself pro se, you need to make sure that you look at anything that you cite to us.
I realize that after
Okay,
the
I'm just
fact, Your Honor.
making the point. We'll return to the substance of your appeal when you come back. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Caitlin Connolly, and I represent respondent, Mrs. Lockwood. This appeal is simple and straightforward. It presents a very common scenario in divorce cases where the moneyed party is unhappy with the pendente lite order and does not want to pay the court-ordered support.
Well, he's also arguing that the court imputed, took an aberrational year to impute what his annual income would be.
Right. I mean, as you yourself pointed out, it is plain on the face of the court's decision that she did not do so. She accepted his argument that 2022 included $175,000 of insurance proceeds that were aberrational. That wasn't documented, but she accepted it for the purposes of this pendente lite order and imputed a much lower income to him. And I think it is important to note that many of appellant's arguments are misguided because they dig into the weeds of a 2023 tax return he prepared for himself during the pendency of this litigation, whereas the court expressly found, as you yourself also pointed out, that the party's taxable income was not a reliable picture of the funds available to them for supporting their family. There is a key document that appellant himself created and provided to the lower court, and I'll give the citation because I think this is really, whereas so many of these cases, there's disputes over what is the marital lifestyle, what is the status quo, what are the expenses. We don't have that dispute here because appellant provided, the record citation is R1124, a household.
Are you talking about Exhibit U? A household?
Yes. And it shows that it's just shy of $400,000 of annual expenses, and he expressly notes on that document that those are and had been covered by him entirely since 2022. This motion was decided in 2024. So
there's I think he cites to a 0.5%, although I don't know what that means, 0.5% that is received from relatives.
Yes, the lower court also clarified that during the oral arguments of the motion, and I believe that was that not 50% of the household budget, but 0.5% being covered by the family, although that remains somewhat unclear because what is undisputed is that Mr. Lockwood received over $100,000 in funds from his parents post-commencement that were not used to support the family. So it does appear that Mr. Lockwood has substantial family funds available to him to meet expenses, and that, and this is in the record as well, throughout the marriage, the parties also received funds from his family, and that funds flowed quite freely back and forth between Mr. Lockwood and his parents.
Counsel, can you respond to the double shelter argument?
Yes. The court found that there was a lavish marital lifestyle based on, in part, on this undisputed budget and the fact that the party's child is in private school and they had net season tickets, et cetera. The court only awarded, though, against that backdrop, $1,000 in spousal support monthly and approximately $1,600 in child support, which is well below what Mrs. Lockwood would have been entitled to based on the calculation. So the court was explicit in the decision that with respect to, in two different places, both spousal support and child support, with respect to the spousal support, she was taking into account his direct payment of those costs in awarding the $1,000 per month in spousal. And as to the child support, she declined to apply the CSSA above the statutory cap, expressly, again, because he was paying those direct costs. So if she was just using the CSSA and the spousal support guidelines, it would have been a much higher
Counsel,
number.
can you point to in the record where she made that ruling? Because I didn't see that. Is there some trade-off between the payment of the cost of both the marital residence and the other types of support, whether it be marital or
Yes.
child support? Where is that in the record? Because I didn't see the court below making that distinction.
So in her decision, I have the record citation, I'll have it right here. Okay, so I believe she has a very thorough discussion of the law and the methodology she used for the support. That's pages 5 through 9, and that looks like it's record citation, that's 13 through 17. And so on page 14, sorry, here she's still going through the background. On page 16, she says, and this is the second, the last full paragraph on that page, accordingly, the court upwardly deviates from the guideline amount and awards pendente lite maintenance of $1,000 per month to Ms. Lackwood. The court also directs Mr. Lackwood to continue paying the carrying costs of the parties' 2 apartments and the child's private school tuition. This upward deviation considers these direct costs paid by Mr. Lackwood. So that's one piece of it. The court also notes that Mr. Lackwood had complained that Mrs. Lackwood wasn't paying the mortgage timely, and so that is part of why she granted him the relief.
Counsel, isn't that an assumption rather than, or an inference rather than a direct quotation from the court that it was essentially a trade-off? Since the court lowered the payments for other items, the carrying costs will have to be borne by the husband. Is that what you're saying?
She did not expressly state that she was doing that to avoid a double shelter allowance, but again, on the following page, she references it again in relation, so that's record citation 17.
Isn't it clear that it would be an impermissible double shelter unless you expressly state there was a deviation based upon certain factors? And in this case, I don't see in the record where there was an explicit determination by the court below making that determination.
That there's well, it's implicit. It is important to note that in plaintiff's underlying papers, she spelled out the family budget and expenses and identified $32,000 of monthly expenses that she needed to maintain her household for herself and the child. So what the court did was, by only awarding her $1,000 in spousal support and $1,600 in child support, the court left her with approximately $9,000 per month in basic living expenses for herself and the child, and also allocated 37% of the add-on expenses to her. So although it's not made clear in this way, the court ordered Mrs. Lackwood to pay $120,000 a month towards the support of herself and the child. And so if you look at it that way and you have the undisputed budget of $400,000, she's paying a large percentage of that household budget. And so you can see that she put it into different buckets, but there is not an impermissible allowance.
Is there any, last question, I'm sorry. You mind?
It's okay, please.
Is there any case law that would support your argument that an inference or an assumption which deviates from the law, and specifically the impermissible double shelter, look at Levin versus Levin and the other cases, that there is leeway from the court to make that assumption without there being an explicit determination by the court below? What case stands for that proposition?
And I'm not aware of any case that says that. I will note, maybe I didn't answer this clearly before, the court did expressly state that she is deviating from the CSSA. Actually, there is a case that says, we have it in our brief, that says—
With regard to double shelter or regarding imputing the income?
Regarding the double shelter. It's in that same paragraph. The court says, that the guideline support would have been $0, but she was deviating upwards. She was deviating upwards to $1,000 per month in light of the direct costs paid by Mr. Lackwood. And I'll note that was a reduction from the interim support awarded, and $9,000 less per month than Mrs. Lackwood had requested.
What page is that on the decision?
That is record 15?
Page 13?
16, I'm sorry, Your
16.
Honor.
Okay, so I heard page 16. I'll look at page 16 again.
16.
Thank you. I'm
16
sorry.
and 17.
Thank you, counsel.
Thank you.
Just imagine that what I'm saying is true and there's no hidden money. I'm going to go bankrupt in about 3 months. My son won't have a place to stay. I can't file bankruptcy because I am in a business, SEC license, and I will lose my license. I can't afford this. The moneyed spouse is not me. 1 year, I made a lot of money, and it was aberrational. If you look at the tax returns, and if you look at the forensic on 1307 and 3157, 2 reports explicitly go through all the finances. I'm not hiding money. She got a $250,000 job that she turned down 4 months before hiring her attorney. I was the primary caregiver. It seems like I'm getting a primary caregiver penalty. Household budget that she talks about, this was trying to show that we have fixed costs and that we are sinking. This wasn't trying to show that, hey, I can afford it all. We started off with, $450,000 in debt. Now we're at $750,000, $800,000. This is too much. Nothing is being hidden here. Fire insurance, that $600,000, it masked everything. It masked everything. We took the money, some of it went here, some of it went there.
Thank you, Mr. Lackwood. Thank you, counsel. Nahara Ordonez v. 260 Partners LP.
Good afternoon, Your Honors. Roger Sacker, Newman Ferrara for the appellants. We are here once again on a J51 case. All of you have, at one time or another, heard at least one J51 case, if not many more. The most recent is a case that came down, Justice Rosado, you were on that panel. Alekna, Mr. Bierman was formerly on that case. It seems to indicate that with respect to pre-Roberts deregulations, if the tenants can show a plus factor, something indicating that it's more than just reliance on DHCR, they can challenge that at trial and seek the default formula.
And so what's your plus factor here?
Plus factor here, there's a couple of them. Number one, there is testimony that Mr. Rothkin, the late Mr. Rothkin, knew about Roberts and didn't do anything. He sat there for 5 or 6 years after Roberts and didn't do anything with respect to this building. However, with respect to the building owned by D-Day Properties, he did register once he got sued. So I think those are 2 very good plus factors.
Their comeback to that is that was a litigation strategy, right?
Yes, but that still doesn't solve that he knew about Roberts.
There's no question that they knew about Roberts.
Right. So
They admit that.
They admit that. And once you know about something, you have an affirmative duty to act. I think we cited a case from 1793 that once you're on notice, you have to do something. Talbot v. Jensen.
How do you respond to their position that they were waiting, despite Roberts and despite having the Court of Appeals of the state speak, that they were waiting for guidance?
You can't sit there like Vladimir and Estragon and say, oh, I'm just going to wait and see what DHCR is going to do. And the reason is because if you do that, if you register in 2016, you get a 2012 base date. If you register in 2011, March of 2012, when Gersten came down, you get a 2008 base date. So what they're saying is I'm allowed to sit there, keep charging tenants free market rates, keep taking more than the RGB allows, and I get the benefit of DHCR not acting. That you're rewarding.
They also continue issuing leases with the deregulation rider, correct?
Correct, Your Honor.
So, counsel, how do you deal with Gomes? 'Cause Gomes was the second department, which I know we've dealt with it. I sat in Montara. below, and my colleagues here affirmed it, and that stands for the proposition that sophisticated parties can't have ignorance of the law and justify it without doing the right thing. So that's Montero. But then Gomes came down, and Gomes had several cases. I believe there were 27 prior to Roberts, 8 in 2010, 12 in 2011, 7 between 2012 and 2015. And in Gomes, the post-Roberts cases, they found a question of fact based upon totality of circumstances. Similar to this, there was confusion, there was all types of arguments that were made that I did not know. There was an affidavit put in saying I was confused, similar to here. So why shouldn't we follow Gomes?
Well, Gomes does say that you can have pre-Gersten, you can challenge pre-Roberts deregulations.
I'm talking about post-Roberts. Gomes, there was post-Roberts.
Post and pre, it says both.
I understand.
I'm misunderstanding your question.
Let me be clear. Pre-Roberts, I think everyone that's clear. You have to show something more, as my colleague just said. Let's talk about post. I don't want to talk about pre. Pre is a different animal. I don't want to deal with that. I want to deal with post-Roberts. Post-Roberts, Gomes, I believe, states and stands for the proposition that if you state in the record that there was some confusion based upon the totality of the circumstances, that would give rise to a question of fact, and you have to go to trial. How do you address that?
I agree with you. That is what Gomes says.
Okay, fine.
The only question is that still going to be the law tomorrow when Ross gets argued at the Court of Appeals?
Why should we not defer to the second department that's come down with that decision?
I think you did in Elecna.
So that's the next question.
Right.
What's the confusion in this case?
Their confusion is when when the Court of Appeals issues its decision in Roberts, what are we supposed to do? How are we supposed to register? Well, you have a job. DHCR had a formula. You just had to go to them and ask. I mean, you saw it with the 4 landlords in Regina. You saw
What did they do?
nothing. They sat there like
How long?
Until 2016, right?
Until 2016.
And after the FAQ came out, did they completely comply with it?
No, they filed with preferential rents.
Right. And
so-
they kept issuing leases.
Right.
The writers, right, charging the inappropriate rent. That all continued.
That all continues, and this is what Gomes is saying. Gomes is saying you could say confusion, and that just gets you to survive till trial.
Correct.
Yes.
Agree. And Elecna as well.
And Elecna as well.
Right. You got it right.
Okay, thank you, Judge.
Good afternoon. May it please the court. Hal Bierman, Greenberg Trarek, on behalf of respondent defendants 260 partners. This appeal is appellant's third attempt to overturn this court's decision. This court's decision in June of 23.
But counsel, this is one of the most dynamic areas of law that I've ever heard of. Of course he's going to do that. I mean, I don't know. I mean, it seems like it's a legitimate second motion for summary judgment.
But it's
Whether
not.
I agree with the result or not, I'm not sure I would focus on it.
I just want to make one point. They made a motion to renew based on the new legislation. Their point is that the 2024 legislation says we don't look at the common law fraud. We now look at whether or not the landlord knowingly
Gotta have knowingly,
engaged.
but then it's totality of the circumstances.
Knowingly engaged in a fraudulent deregulation under a totality of the circumstances. Having that legislation in hand, they came back to this court. They asked to renew this court's decision. This court said no. After due deliberation, we adhere to our decision. They put all these arguments in front of this court. Having lost here,
But
they
is
go
this
back
court,
to Supreme
but counsel, is this court the proper forum for something like this question? Shouldn't it have gone back to, maybe the prior panel was saying, send it to the trial court, let the trial court sort this out.
No, they had the option, right? They were within their time limit to make the motion to renew. It was proper to do so. The court
Counsel,
didn't only
a
say
mo-
deliberation.
A denial and a motion to renew is not on the merits. It just says that we're not reviewing it, as my colleague said, and obviously if there's a change in the law, we all know the immense change that came out with there was a 2023 amendment, a 2024 amendment. Everything was changing. A matter of fact, in my Montero case, I changed my mind because they changed the law on me. So I changed my mind on the law because the law changed. So what's wrong with them coming back and asking for clarification under the law? It's a moving target.
Well, they did. and it was denied. And then they went back to Supreme Court, and Supreme
Can we
Court...
get to the merits, because I don't want to waste all the time, please?
Sure, no problem. So on the merits itself, it's the knowingly engagement. As we discussed, 2009, Roberts comes out, and the Roberts Court itself recognized it was going to lead to innumerable unanswerable questions. And it took DHCR 7 years to address, what do we do here? So that's what we were talking about. We're talking about the units were deregulated pre-Roberts, 28 units pre-Roberts. The other 9 shortly after Roberts. It was still unknown. The idea that Mr. Rothkin, in a different case, testified about his knowledge of Roberts, also testified he didn't know what to do. He wasn't sure either. Nobody knew. The industry was in flux. And then DHCR comes out with an FAQ, and what does this landlord do? It re-registers the units based on the FAQ with there were slight differences in opinion, right? As to whether or not the DHCR was guidance or rule. So it filed the registrations based on the rent it was charging. And that's plaintiff's main concern with how we address the FAQs. But the truth of the matter is they didn't know. They looked at the guidance. They took the guidance in. They registered the units. How is it possible that from 1993 to 2009, when Roberts was decided, when every landlord in this state was following DHCR guidance, that they knowingly engaged in fraud by deregulating before Roberts came out?
What about not re-registering after Roberts and after Gersten?
Well, Gersten said that Roberts was retroactive, but there was still a question about what to do with these units, whether or not they had to be re-registered. 2016, DHCR, yes, they have to be re-registered. Here's how you do it. And this landlord did it.
Court of Appeals wasn't clear in Roberts?
I'm sorry?
Court of Appeals didn't address that in Roberts?
It wasn't clear that they had to be re-registered after the fact. The fact of the matter is, how do you do it? How do you calculate the rents? What should the rents be? When do you have to re-register? How do you have to have these rents stabilized? It wasn't clear from the 2009 decision in the Court of Appeals. And you could say that because 2012, we waited till 2012 until Gersten came in and the appeal was withdrawn for to be retroactive. If Roberts was clear, that was
at the very least on March 6th of 2012, when the appeal was withdrawn, the seat was a little bit more settled. So instead, you wait from guidance from who? Did you ask for guidance?
The guidance is supposed to come from DHCR.
Did you ask for guidance?
There's nothing in the record suggesting that guidance was asked
So instead, you wait how many years before guidance came?
2016.
During that time, you continued issuing leases that had the riders, correct?
Correct.
In spite of Roberts.
In spite of Roberts, but Roberts stands for the proposition that you can't deregulate while receiving J51. 29 units were deregulated before Roberts was decided. And at that point, how can you knowingly engage in fraud?
There were also units that were deregulated after Roberts, correct?
There were those units. There was a question of fact, as lower court determined, that will be tried under the totality of the circumstances, whether or not it was fraudulent. We're not suggesting the tenants aren't.
Why is there a question of fact there? When there's an admission that you knew about Roberts, there's an admission that you continued issuing the leases with the riders, and that it's in violation of Roberts.
Because knowing about, first of all, most of the units, the 9 units post-Roberts, most of them were deregulated right around Roberts, within a year or two, so before Gersten. So there's a question about whether or not the landlord, again, knowingly engaged in a fraudulent scheme to deregulate under a totality of circumstances, and that's what will happen at the trial court. The trial will determine for those 9 units whether or not fraud. You still have to prove fraud. This knowingly engaged.
Can I ask you, do you believe that Gomes and Elecna is good law?
Gomes and Elecna are good law. However, they also both state in there that pre-Roberts deregulations.
Let's talk about post-Roberts only.
Pre-Roberts are.
I'm not talking about pre. Talk about post.
About the post, the lower court correctly held that there's an issue of fact that there has to be a knowingly.
How is this case different than Gomes and Elecna?
Nothing in this case is going to show. There's
Gomes
no
for the
discovery.
proposition that whenever there's an allegation of fraud, that summary judgment cannot be had?
No.
Good, because I don't either.
The idea here, however, is that we have to have, there's this 7-year-old case. There is simply not an iota of evidence in this case that there was no depositions taken in this case. None. There is nothing that the plaintiff will be able to prove to carry its burden at trial that this landlord knowingly engaged in a fraudulent scheme to deregulate.
Thank you, counsel.
Thank you.
Oh, did you have another question?
No.
Thank you, counsel. So, counsel, what about that point about we need discovery here?
We can seek all this information at trial if we need to. Bear in mind also that not until 2024 did we even get the new legislation that told us, this is what you need to lay out. So we can always ask to vacate the NOI and try and get this information based on this new law.
Is there any case law that you know of, and you're doing this a lot, I guess, that any court has granted summary judgment without depositions being done with regard to fraud in a J51 case post-Robert?
You asked me that question in Montero too, Judge, and no, I don't.
What are you asking for
Can I
here?
have the answer, please?
Well, what we're asking for now is it changed a little bit, right, from our
Can
opening
you
brief.
answer my question? Is there any case law?
I did.
You did.
No.
What did you
No,
say?
I said no.
I didn't hear. I didn't hear. I apologize.
Same answer I gave you in Montero. I'm sorry. Can you repeat that question, Judge?
What are you asking for here?
So here what we're asking for is, with respect to the pre-Roberts deregulations, because ELECNA came out after our opening brief went in.
Forget about pre-Roberts. What are you asking for post-Roberts?
Post-Roberts, I think we are entitled to summary judgment on that. At a bare minimum, we are entitled to a trial there. Pre-Roberts, same thing.
But summary judgment on a finding of fraudulent scheme?
Correct.
On both pre and post?
No. Pre, I think ELECNA's pretty clear, and Gomes is pretty clear too, unless something happens at the Court of Appeals tomorrow. Which very well could.
Pre-Roberts, you have to have a trial.
Pre-Roberts, I think at this juncture, you have to have a trial. I think that's the way the case looks.
Post-Roberts, we could search the record and grant you, or not search, grant summary judgment to you.
Correct, I think so.
Why not do both at trial at the same time?
Because if I could at least, hit a single, then, I'd really like to do
Good
that.
answer, like always.
All right, thank you very much.
Thank you, counsel. Thank you both.
Very good.
People v. Tiara Richards.
Good afternoon, Your Honors, and may it please the Court. Garrett Salzman, legal intern at Office of the Appellate Defender on behalf of Appellant. This case is Ms. Richards' only criminal conviction.
How old was she when this incident happened?
She was 21 years old,
She was
so
21
fairly
years old.
young.
So
Yep.
she served 3.5 years, correct?
Yeah, just under with the good time credit. She was recently released at her earliest possible release date.
And I take it you're not taking any position to the contrary, that the conduct here was serious, right? Someone required 50 stitches.
Of course.
To heal the damage that the defendant did.
Yes, it was a very serious incident, and Ms. Richards has, accepted that. She's accepted full responsibility and expressed deep remorse for what happened.
So why should we grant your request to lower the post-release supervision time?
Well, the circumstances of this incident reveal that it was an aberrational act. It occurred.
No criminal convictions, right?
No criminal convictions, exactly. This is her only one. It occurred during an extremely difficult period in her life. She had just lost her job. She was in an abusive relationship, and she had just learned that her mother was diagnosed with stage 4 pancreatic cancer.
And that was weeks before her mother died.
Just
We
weeks
know
before
that.
her mother died,
So
exactly.
how do we justify this reduction based on 50 stitches?
She's acknowledged that this was a serious incident. She's accepted full responsibility. And I think in addition to that, her behavior in the years since the incident reveal that she is a different person now. She made a mistake. She's accepted responsibility and is ready to move on and live a law-abiding life. This was
She was
her
released on good because she behaved herself and she did well in jail, correct?
Yes, she was released at her earliest possible conditional release date. In the years since this incident, she has been charged with no other offenses. And this really was an aberrational, isolated incident for her.
What does 2.5 more years of post-release supervision, how does that negatively impact her?
I think there's a number of things, Your Honor. For one, she has family both in New York and Florida, and so it limits her ability to travel and visit her support systems. It's also served to limit her job prospects and ultimately will delay her full reintegration into the community. So instead, a 2.5-year post-release supervision term would be more appropriate here.
Well, to play devil's advocate, why can't she go to her probation officer and say, hey, can I go to Florida for 6 months? They have a job for me there.
She may be able to do that. However, Your Honors do have discretion today to reduce that term and allow her to re-enter the community, when she's ready, and, give her the freedom to travel, and visit those support systems.
Let me play devil's advocate as well. The top charge was attempted murder, and she faced up to 25 years in jail, as well as, we know the facts here are rather gruesome. The defendant stabbed a stranger multiple times in the left arm, chest, and upper back. This wasn't just one strike, and then it was multiple times. And the attempted murder charge, and here the defendant pled to a 3.5 years jail. Why is that excessive?
Well, she was given the maximum post-release supervision period, and Your Honors have reduced sentences in the interest of justice for similar cases.
And with longer times, correct?
Sorry?
And with more time in jail, correct?
With more, yes.
On homicides?
There was a couple of cases, People v. Anonymous originally charged as murder 1, as well as People v. Blackwood, also originally charged as attempt murder 2, took a plea to assault, and then later on was reduced as well. And so similarly here, especially considering...
So how much time was it in those cases? What did they reduce to?
Sorry, one moment. In People v. Anonymous, originally it was 8 years with 5 years post-release, reduced to 5 years with 2.5 post-release.
It went from 8 to 5?
Yes, Your Honor.
It's incarceratory time, correct?
And the post-release supervision was similarly reduced from 5 to 2.
You're not asking for the incarceratory time, that's served.
Yes.
For the reduction in post-release supervision.
Yes, exactly. We're just asking for a reduction in the post-release supervision.
What?
Sorry?
What's the reduction you're seeking?
2.5 years. Yep. And in addition to, the circumstances revealing that this was an isolated incident during an extremely difficult period in her life, there are also a number of mitigating circumstances from her childhood that support a reduction.
How do we know that she's getting the mental illness treatment that she needs now?
Yes, so since she's been released, she's been actively engaged in programming. She's been engaging with the Fortune Society and is about to complete a program with them and is actively seeking employment to be able to support herself.
What is her mental illness diagnosis?
I believe she was diagnosed with a number of different disorders as a child. I believe it's in our briefs. I don't remember offhand, Your Honor. I see my time is up unless you have further questions.
Thank you. You have time in rebuttal, counsel.
Okay, thank you.
Good afternoon, Your Honors. Andrew Loizidi is appearing for the people, the respondent, and may it please the court. First, I'd just like to state that the defendant knowingly, intelligently, and validly waived her right to appeal, as the trial court made sure to differentiate the trial rights from the appellate rights. Defendant had on multiple occasions discussed the waiver with her attorney and confirmed on the record that she understood the waiver of the right to appeal.
But didn't the court mislead the defendant regarding the issues that would survive a valid waiver, stating that only two would survive?
I believe in that, in the context of that, Your Honor, the judge was saying, well, these are two examples of what would survive, but these are not the only limited thing. And to that point, immediately after saying that, there was a brief break in the proceedings where the defendant discussed the plea waiver with her attorney, and then she confirmed, yes, I understand exactly what I'm waiving to. And the written waiver also clarifies any issues that there may have been in the oral colloquy.
So how did the court explain to the defendant that the waiver of the right to appeal is separate and distinct from the trial rights that they waived?
If we look at the, excuse me, Your Honor, if you just bear with me one quick moment, I can tell you, based on the on the colloquy.
I think you're going to rely on that the people are requiring that you waive your right to appeal.
Yes, Your Honor.
What page is that, counsel? Can you cite chapter and verse?
Yes, it should be that requiring defendant to waive a right to appeal. This is in the plea minutes page of 7 to 8.
Okay.
So it's that sentence. The people are requiring that you waive your right to appeal that signals to the defendant that the right to appeal is separate and distinct from the rights that she just waived.
Correct, Your Honor. And that it was part of this plea deal, that it was a condition of the plea deal that she had to waive her right to appeal.
I agree with you that it definitely indicates to the defendant that it's part of the plea deal. I
Yes, Your
just
Honor.
don't get the second part.
This came from the prosecutor, correct? Not the judge.
I'm sorry?
What you just stated that the prosecutor stated? I'm sorry.
Oh, no. I apologize. That as part of the deal, the people were requiring the defendant to waive her right to appeal.
And that informs the defendant.
That it's separate from the trial rights, that this was a requirement.
And it saves the court, who didn't say anything about the appellate rights being waived.
I'm
Are
sorry.
you saying that that statement cures the court's lack of addressing the appellate rights he was waiving?
No, no, Your Honor. I'm simply saying that it helps to differentiate the
Yeah,
trial
but the
rates.
court failed to explain to the defendant that the right to appeal was a separate and distinct right then from the trial rights. Are you saying that fixes it?
I'm not saying that that necessarily fixes it. What I am saying is that it does help to differentiate, and even if that weren't the case, that the written waiver certainly helps with that, and also the fact that defendant had the opportunity to speak about this with her attorney, and that she said that she understood, and that her attorney explained everything to her.
So do you think, in light of the circumstances here, where it's the defendant's first, I think, contact with the criminal justice system, she's young, she may have some issues, that sentence alone, that the people are requiring that you waive your right to appeal, signifies that this is a separate and distinct right?
Well, even if at that particular sentence does not at the moment register it, I would again argue that
You're going to rely on the written waiver.
well, not just the written waiver, but also the fact that the defendant repeatedly spoke with her attorney about this on the record, and again acknowledged that her attorney explained everything to her and that she understood everything, that helps to, if there was any ambiguity, that would help to cure that, and that she would have knowingly, voluntarily, and intelligently.
Counsel,
Yes,
let's
sir.
say that we find that the waiver is not valid. Okay? Why should we not grant the defendant's application and reduce her post-release supervision?
Well, I would say that again, as Your Honors were discussing earlier before, that number one, given the horrific nature of the incident that happened here, where the defendant attacked this woman on the bus, and what was just an ordinary day of traveling resulted in this woman requiring 50 stitches to be healed of her wounds. 50, that's 50. And again, the fact that she...
I think that we all agree that 50, no one wants to get 50 stitches, right?
No, I know I certainly don't.
The law prohibits it.
Just a bit.
Why was she offered 3.5 years in
Yeah.
jail?
Exactly.
Well,
Because of the 50 stitches.
Well, I think it was that number, given the, now again, I can't speak for the prosecutor who handled this at the trial level, but I would say that it most likely, given that it would, to try to, number one, prevent the, not force the victim to have to come up to this, to testify and have to relive the traumatic experience of what had happened to her, but also given, again, the circumstances of defendant's background, and this helped to go into the plea offer that they offered the defendant to.
So the mitigating circumstances that they are now arguing were considered at the time of the
Absolutely.
plea?
Yes, Your Honor. In fact, we're in front of the trial court and in front of the sentencing court when the defendant was sentenced. The sentencing judge even said as much, that I understand you had a rough background and that you've gone through a lot, but that you can't do things like this, and that they hope that with the prison sentence and the 5 years post-release supervision, that this would help her to reintegrate into society and give her the help that she needed.
Your argument is that the extra 2.5 years of post-release supervision is somehow going to help her reintegrate into society?
Yes, Your Honor. If I may just briefly state that her own record shows that she might need help with post-release supervision, and that she's had issues of authority. She even stated herself that, I think it was at age 16, she ran away from home because she didn't want to listen to her parents' rules, and that prior to
This is her first dance with the court system. I mean, with the criminal justice system.
a very serious one at that, Your Honor. I would say yes. Absolutely.
So the minimum period is 2.5 years, correct?
For post-release supervision, yes, she received the minimum sentence of incarceration.
I understand, but the PRS, the minimum is 2.5,
Yes, Your
maximum is 5.
Yes, Your Honor.
And we can choose any number in between.
If that is the court's discretion, yes. But the people believe that the 5 years of post-release supervision was not unduly harsh or severe, and probably will actually help her in the long run. And unless Your Honors have any further questions, I'd like to submit the rest of my brief.
Thank you, counsel.
Thank you.
Yes.
Since the mitigating circumstances, as your colleague alluded, have been considered, and they were considered at the time that the plea was offered, why should we tinker with that? Why should we not leave it alone?
Well, Your Honors do have discretion to reduce sentences in the interest of justice without deference to the sentencing court, including for lawful and bargain for sentences.
But the things that you're arguing to us now were considered by the sentencing court and by the people when they made the offer of 3.5 years in jail and 5 years post-release supervision, considering the facts and considering the mitigating factors.
Well, I would argue that in addition to that, Ms. Richards in the years since has shown that she is a different person, has grown a lot, and is ready to engage as a law-abiding citizen. And so, in addition to the circumstances showing that this was an aberrational, isolated incident, as well as her significant mitigating circumstances stemming from her traumatic childhood, there are a number of different reasons why her post-release.
How old is she now?
She's 26 years old.
26?
Yes, Your Honor.
And I'm going to ask you the same question that I asked your colleague. 2.5 years is the minimum? 5 years is the maximum?
Yes.
We can pick any number in between?
Yes, Your Honor.
Why should we pick 2.5 as opposed to 3.5 or 4?
Well, in addition to the factors that I mentioned, the research that we cite in our brief shows that a period of about 1.5 to 2 years gives the appropriate amount of time of post-release supervision to allow full reintegration into the community. And so beyond that period, there's diminishing benefits. And so for that reason, a period of 2.5 years would sufficiently allow her to reintegrate.
How much time does she have to go on post-release supervision?
She was only just released a couple months ago, so 2 years and 3 months about. Yeah.
She has 2 years and...
Oh, I'm sorry.
How much
With
does-
5 years, yes. So nearly 5 years.
Counting if we reduce it
Yes, if we're reducing it, exactly.
But if we leave it at 5, how many more years and months does she have to do?
It would be about 4 years, 10 months more.
About 4 years.
Yep.
10 months.
Yep, Your Honor.
And 10 months.
And 10 months, yes, so nearly 5, exactly. And, as mentioned, the appeal waiver is invalid and is no bar to reaching the excessive sentence claim. If Your Honors have no further questions, we respectfully request that you reduce her post-release supervision term to 2.5 years. Thank you.
Thank you, counsel. Thank you both. What's up? I wasn't sure about that. Yeah. No, I like to say that when I can. I know you do. Hold on, counsel, 1 second. Okay, please.
Good afternoon, Your Honors. May it please the court, Joseph Farini on behalf of 494 8th Avenue, LLC. The photos of the sidewalk's condition, which are at pages 299 to 310 of the record, speak for themselves. They show minimal height differential with respect to a depression that plaintiff herself characterized as, quote, a little dip.
So, counsel, let me stop you. I thought that the plaintiff on page 70 said that it was 1 inch to 1 1/2 inch, and the superintendent, Mr. Muhammad, said it was 1/2 inch. Isn't that the case?
He said it was less than 1/2 inch.
I apologize. You're right. Less than 1/2 inch. So, why isn't there any objective measurements here? Why didn't the defendant measure it before they repaired the sidewalk?
Well, the record is unclear as to whether he did or didn't measure it. But what he did do.
Let me understand that. I've read Mr. Muhammad's affidavit. I did not see anywhere within that affidavit that he said he took a measuring ruler, he sat on the ground, and then he measured it. Are you telling me that he did a measurement that I don't know about?
No, what I'm saying is simply that the record is silent one way or the other on the issue.
Okay,
But
so
no,
there
absolutely.
there is no measurement that someone took that has been alleged here. Is that correct?
That is correct. But what we do have is we do have these photos themselves. We do have.
Let's go to page 308. Do you have page 308, please? It's one of the
Record
photographs.
308, it's the one that shows the biggest differential, I think. And you kind of say that, you quote Justice Stewart in the pornography case, I know it when I see it. But the problem is we don't know it when we see it. Photographs are not perfect. And so it's very hard unless there's a ruler by the crack to know that we can say, as a matter of law, that this is an insignificant.
But the key here is that plaintiff, okay, whereas our Mr. Superintendent was looking at this all the time, and I feel like we're getting in the minutia, whether it's a little bit over or under 1/2 inch, courts still find trivial defects. In fact, as even their expert relies on, in the record, we cited where he was for the defense, and he said that less than a half inch or less than an inch, courts commonly find a defect here. And critically, he did not assert, their expert, 15 pages of a report, and he was unwilling to say that this defect, even armed with plaintiff's characterization, which is honestly off the cuff if you read her deposition, that this was an inch or greater, he does not assert a violation of New York Administrative Code 19-152, paragraph 4. And he always goes to that. In the case that we cited, one of the cases, he always pulls that out if he can. He goes to that, and that's the paragraph that says if you have a substantial defect of greater than a half inch, it's a substantial defect under the New York Administrative Code. He does not assert that in
one
this
factor
case.
to consider. It's not like if it's, that you get you denied summary judgment, it's more than 1/2 an inch. It's a factor to consider.
Well, it's a factor that consider, but that's incredibly telling here that this is not a crack that's in excess of a half inch. It belies all common sense that this expert, this paid expert, wouldn't go to his tried and true go-to allegation that he uses in the cases. Instead, what can he come up with? He only calls this a
Let me bring you
defect.
back to the parties, because there's only two people that actually gave measurements. We have the plaintiff, who said it was almost an inch and a half, and we have the super that says it's less than a half an inch. And I took a paper clip. It's about that. This is about a half an inch. And who can tell on a lifeless, not a 3D photo, whether it's that much high without a measurement? Isn't it virtually impossible, or at the very least inconclusive, from the photographs to determine that issue as a matter of law?
Apologies, Your Honor. That's where I would rely on his expertise and his testimony that he inspected this. He was.
Who is he, please?
Sorry, the building superintendent.
What training does the super have in terms of being an engineer or of any measurements without having a ruler?
I would respectfully submit.
Is there anything in the record that would show that he has some better expertise than the plaintiff?
Well, he said that if he encounters a crack that's more than an inch, then he would pass that along to the owners of the building. So there's that testimony from him, and then there's also his, and I apologize, I see him over my time, just to finish the point that he did testify to his intimate familiarity with this crack, and that it did not pose a substantial hazard, whereas all plaintiff's expert can say is that
Why did the landlord then subsequently fix the sidewalk if it didn't pose a danger to the public?
That is in the record, Your Honor. It was repaired because of a crack that was near the curb that was completely unrelated. It was a violation for a crack near the curb. That's in the deposition of Mr. Haddad, the building owner, and then in the deposition of
I asked them why, before they repaired the sidewalk, why didn't they take a measurement in order to show this was a half an inch? This way we would know rather than having estimates or an assumption.
I don't have access to that information.
Thank you, counsel.
But can I just,
Counsel,
never
we have
mind.
time for
Thank you, Your Honor.
Unless there are further questions. Thank you, counsel.
Thank you.
Good afternoon, Your Honors. Jason Krakauer, Rafelson Levine Law Firm for the respondent. My adversary states that you guys were getting into the minutia, and I believe that was exactly the point that you needed to get to, and that is that this is a quintessential state question of fact case.
Who done it?
Sorry?
Who done it? What is
Who done
it?
it? Yes, Your
Also,
Honor.
Did she, but also all this, the medical records concerning tripping on the police barricade.
Correct.
Game over for you?
Of course not, Your Honor. At worst, for us, it's a question of credibility that needs to be answered by a jury. At best, it's a game of semantics. She states in two medical records that she tripped over police barricades.
She called 311.
I'm sorry?
And she called 311.
And she called 311. But the only two times that she's been under oath, which is at her 50H hearing and at her deposition, she testified clearly and unequivocally that she tripped as a result of the defect in the sidewalk and then fell onto the police barricade. So again, at worst, this would just create a credibility issue that needs to be resolved by a jury. Getting back to the defect at hand, because I do really believe that the statement in the medical record is not an appealable issue by any means, nor is the defect in the sidewalk. But the plaintiff clearly states that the defect is 1 to 1.5 inches.
Can I ask you the same question I asked counsel? I'm going to give you the same time. Why didn't your client measure it? You had the same opportunity to measure it, and she took a video. She called 311. Why didn't you have an expert measure it before the sidewalk was repaired?
We tried to, Your Honor. There were sidewalk was repaired very, very quickly after the accident.
I thought it was 2 years after the accident.
I do not believe it was 2 years, Your Honor.
I actually have it. If you want, I have it. I'll tell you what pages is it. 702 and 703 of the record. I think the super says it was 2009, but you're right, there's no specific date.
Correct, and I apologize if it was inspected.
You may be correct. It looks like it's ambiguous.
And either way, Your Honor, it's not her duty to do that. And again, this is the defendant's motion for summary judgment. Ironically, they point to the discrepancy in plaintiff and our papers that we don't have a measurement, but again, this is their burden, this is their motion for summary judgment. So the fact that they're pointing to a discrepancy for our lack of measurement is very ironic, given the fact that they don't have a measurement themselves.
Looking at the photos, can you say that's really 1.5 inches?
As Your Honor just pointed, I think it's very difficult to tell whether that's over 1 inch or under 1 inch, but regardless, Your Honor, that's not even the point. Because if it's over 1 inch, then as a matter of law, it's actionable. We're talking about if it's under 1 inch, it's still actionable.
Why didn't you answer counsel's question, the administrative code? The first thing I would have said was the administrative code says more than 1/2 inch requires that it be remediated. So why didn't your expert opine on that?
Because he's only looking at photographs. The only two people that actually saw this in person.
No, but counsel, he knows that the plaintiff testified it was 1.5 inches.
Correct.
So based upon the record, which he stated in his own expert opinion,
Correct.
it was 1.5. So why didn't he say that was a violation of the administrative code? That actually struck me as being really
Sure.
Ambiguous to me.
Of course, and I don't want to put words in his mouth or guess as to his reasoning, but my best guess would be because he himself did not have that information, and he's not going to rely on somebody else's testimony if he himself did not visualize it.
Experts rely on testimony all the time, no?
Right. Yep.
Isn't that the case?
It is the case, Your Honor.
I'm sorry.
And so I can't answer why he did not put that in there. He does, however, testify that there was, sorry. He opined that the defect posed a substantial tripping hazard under New York City Administrative Code 19152. But again, whether it was over 1 inch or under 1 inch, according to Trincier, the peculiar facts and circumstances of this case make this a tripping hazard because it was chipped, it was rough, it was jagged, and it was an abrupt change. It was not a slight change, it was an abrupt change, and most importantly, and is cited by Justice Kingo in his decision, but this court's ruling in Argenio is directly on point. It happened in a highly trafficked area in Penn Station between Christmas and New Year's. And you can even see in the video, there's a crowd of people around, and plaintiff testified that she tried to maneuver around them as she entered onto 8th Avenue. And this case is directly on point to Argenio. So regardless of whether it was 1 inch to 1.5 inches, whether it was less than 1/2 inch, it's still based on the peculiar facts and circumstances of this case, it is deemed a tripping hazard and actionable. Thank you.
Thank you, counsel. Please.
I do want to make sure we're clear on what the expert does and does not say. He does not call the crack a substantial tripping hazard. That's nowhere in his report. He says that the longitudinal line, okay, that is, he refers that as a tripping hazard that one could have their ankle twist and they could lose balance and fall. As to the little dip, all he says is in a footnote, which that's the testimony of plaintiff. I stepped in the little dip and lost balance. In the footnote in his report, all he says is there's a risk of someone losing their balance in the little dip, and that's all he says about that little dip. And then on the last page of his report, he only says that the irregular walking surface is a defect. He doesn't say substantial defect. He only goes so far, and he's only willing to say that it's a defect, and the reason is clear, I submit, from these photos. This is a gradual little dip. She steps in this little dip. it's can be found
That's
on.
the reason why the expert did not raise the administrative code?
And the reason he did not raise head administrative code is absolutely because he knew that this was less than a half inch in its gradual little dip. And that's what is before this court. And then to go to the issue, I will also just point out that plaintiff was asked at her deposition under oath, were the statements that you gave to your medical providers accurate and truthful? And that she did say yes. Those statements were accurate and truthful. So those statements are akin to being offered under oath is our position and should prevent her from changing her story now at this belated stage and blaming something other than the police barricade. And I do want to also point this court to the video because the video is very compelling evidence where she's slowly scanning. And by the way, she can see where she's walking. She has they claim crowds, but she can see where she's walking as she's
Counsel, no question,
cataloging.
you've got a lot to work on in cross-examination if you're trial lawyer, if you're the trial counsel.
All right, thank you, Your Honor.
Thank you.
Thank you, counsel.
Okay, last case, People v. Soto. Please.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent appellant Joshua Soto. May it please the court. By conceding in summation that Mr. Soto was guilty of robbery in the third degree, defense counsel deprived Mr. Soto of his constitutional right to choose the objective.
Counsel, as you know, the people make the point that unlike McCoy, he didn't voice any disagreement with this strategy to the court.
Well, he did. There is record evidence of his disagreement. First, in the charge conference, defense counsel said, when the issue about third-degree robbery came up, he said to the court, I have a problem with third-degree robbery. This is at page 81 of the record. I would love to do that myself personally to charge Rob 3 and tell them to convict on that. That, however, is a D felony, D nonviolent felony. It's the same thing as the offer that my client rejected. Then the lawyer continues, it's my choice. I can do that whether he likes it or not. So there's the lawyer on the record stating that it's his choice to make, not my client's choice to make.
And then there's a
In
closing.
summation, he goes on to expressly concede that. He says the same thing again. He says, Mr. Soto testified that this is a pettit larceny and not a robbery at all, but I submit to you it's a robbery. You have on the record at the charge conference, the lawyer recognizing that it's against his client's wishes, that's not what he wants. And then during summation, in explicit terms, the lawyer says things like, I'm not going to insult you by finding what the defendant testified to. I'm asking you to convict him of this offense.
Counsel was requested that the court charge a petty larceny as a lesser included offense. And the court said, no, I'm not doing that. So then he's left with a robbery 1 and a possession of a weapon. And so he's trying to get his client convicted to a lesser offense than the robbery 1. That's a trial strategy that he's employing. Because he believes that if it goes to the jury only on the robbery 1, he's going to get convicted of that. And my question is, what is wrong with that strategy?
Okay, so
Especially in light of the video.
Under Colville, the lawyer has the right to ask that the third-degree robbery be submitted. You know, the Court of Appeals has said that. That's a lawyer's strategic decision to make. It's not the lawyer's strategic decision to make to tell the jury to convict of that offense when the client has made it clear that he wants an acquittal. He's said in no uncertain terms during sworn testimony.
On an acquittal. How did he make it clear that he didn't want his attorney to argue to the jury that he's guilty of Rob 3?
Well, he made it clear because in testimony, under oath, he said again and again that this was not a robbery, that this was a pettit larceny. or a criminal mischief.
Counsel, he hears his lawyer saying this. Does he say, no, absolutely not? Judge, give me a new lawyer.
No, he did not say that. And clients are told not to speak up in court. They're told that their lawyers are their spokespersons.
I mean, he was told not to testify, and he testified.
Well, he wasn't told not to testify. He was told that the choice was his whether to testify. His lawyer may have in private advised him not to testify, but he took the stand and swore under oath that I did not commit any form of robbery. And then the lawyer got up and said, yes, he did. It's insulting. What he's told you is insulting. That's not what lawyers should be doing. And under McCoy, it may have been a bad strategy, but that's the client's decision to make, not the lawyer's.
Thank you, counsel. You have time in rebuttal as well.
Good afternoon. May it please the court, Assistant District Attorney Max Bernstein for the people. This case is essentially exactly like the case this court decided in Alvarez in 2022. Just as in that case, it's true, this defendant had a preference, express preference, about what charge he would ultimately get. That in Alvarez, the defendant actually repeatedly protested his complete innocence to the crime. But what didn't happen here, and which your honors all picked up on, is at no point did defendant signal to his attorney that he was unwilling to accept a third-degree robbery charge by the time summation had come. The complexion of the trial had dramatically changed from the time of the initial charging conference. And I would just point out, with respect to the charging conference discussion, the admittedly unfortunate statement by counsel that it was his decision to decide whether or not to ask the jury to charge on to convict on third-degree robbery. Justice Peck on the very next page says, counsel, you need to discuss that with your client. And counsel says, okay, judge, I will discuss it with my client. As far as the record appears, we have every reason to believe that counsel and defendant did discuss this, and that defendant did agree after he testified and after things had gone so poorly for him. And I would say the video, Your Honor, was bad. His testimony in his defense was even worse. That all but secured a conviction for robbery. It seems perfectly plausible, in fact likely on this record, that he and his attorney sat down to discuss the charge as his attorney.
So as bad as the defendant's testimony may have gone, he may have sunk his own battleship, right?
Yeah.
But is it proper for his attorney to then get up there and tell the jury, despite what he said, he's guilty of rob 3?
Yeah. So a couple things. I would say it would certainly not be improper if he and his client had discussed it, which we have no record basis to believe.
That's the question here, right?
We have no record basis to believe that they didn't. And Alvarez and McCoy say we need incontrovertible record evidence that that is what happened. And to be clear, Judge, you're right. I think, Judge Rosado, that there was no statement from defendant, who, by the way, spoke out of turn multiple times in this trial and during his appearances before trial. There was also no 440 here, which happened in Alvarez. There was a significant opportunity post-conviction for defendant to have made the record that we're now speculating about whether it exists or not, to show that he did object, actually, strenuously to the decision at summation to concede guilt with respect to third-degree robbery.
Several times in this record, he talks about petty larceny, the defendant himself.
Mm-hmm. There is no question that defendant would have preferred a conviction to petty larceny. I think that's clear. But as Your Honor pointed out, all defendants would prefer lesser convictions, acquittals, if they can get them.
Rob 3 conviction is better than a rob 1.
And I would say on this record, it was a remarkable achievement by counsel to have secured the rob 3 conviction, because the evidence of rob 1 was quite strong. But regardless, at the end of the day, we have no basis for believing that counsel and defendant did not discuss, hey, I know you wanted petit larceny, I let you take the stand, you made the case for petit larceny, but I really don't think we're going to be able to win that battle at summation. Is it okay if I change tact and argue for it? And for whatever it's worth, the comments on summation were not comments about defendant and his client's, defense counsel and his client's private conversations about what defendant wanted. They were just a statement about what defendant had said on the record, which was defendant asked for a petit larceny. That's true. Defendant did tell the jury this was just a petit larceny. Counsel was clearly trying to curry credibility, curry favor with the jury by saying, look, I know he said petit larceny, but it's pretty clear that the evidence doesn't support that charge. This is really a rob 3. And again, as Your Honor pointed out, the key concern that was motivating counsel was that there was a serious risk of a robbery 1 conviction here. Something, if there was an off-the-record discussion, which there may well have been, I'm sure he conveyed to his client, Mr. Soto, there's a significant risk of a robbery 1 conviction here. I think given how things have gone up to now, we absolutely must make the play for robbery 3. And again, we have no evidence of an express objection or even an implicit objection to that change in strategy. And I think under Alvarez and McCoy, that settles the matter. This is one of those rare cases where it is entirely on defendant to make a very clear and explicit record. Defendant didn't, even though he had a 440 opportunity to do so on top of his chances to say something during the trial or at sentencing or after the jury was excused. He hasn't taken advantage of any of those opportunities. And because there is no record of an express objection, there can be no McCoy violation.
Thank you, counsel.
What distinguishes this case from Alvarez, whom I represented, by the way, is that there's this express statement during summation that he is disagreeing with the sworn testimony of his client.
But his client testimony basically confirmed that he committed a robbery.
His testimony, we can disagree about whether it confirmed whether it was a robbery or not, but it's the client's decision to make.
Well, he says he takes something, and that when the store employee comes at him, he takes out an object, and he waves it at the employee. The employee believes that it's a sharp object, and he's, said he threatened to cut me with it. That's a robbery. Whether it's a 1, a 2, or a 3 is something to be discussed, but that's a robbery. That's not a larceny.
And the lawyer's response in that situation should have been to tell the client, that's a robbery, you shouldn't go to trial, which is what happened here. He was offered a D felony before trial.
So you're saying that you take issue with the fact that defendant gets on the stand and says, this is what happened, and then his lawyer, his very own lawyer, gets up in closing and say, don't believe him, he did rob. That's your issue, essentially.
Exactly, Your Honor. And the one thing I would ask...
There's a lot of stuff, counsel, that we're sort of, in order to get to where you're asking us to get, we have to assume or infer a lot of things. He had access to a 440, right? And one wasn't filed.
Well, one wasn't filed because there is and it still could be filed, Your Honor, but there is an on-the-record statement of the lawyer
saying that it's his choice.
Saying that it's his choice, and he was making it. And I think the one thing that this court needs to do, whether you rule in my client's favor or not, is clarify whether that's the lawyer's decision or the client's decision. There's no New York case that says, that answers the question of whether the lawyer is entitled to make that choice to concede guilt to a lesser, or whether that's the client's choice. And
as opposed to asking for a lesser included.
Which Colville, the Court of Appeals, has answered that question clearly. It said that's the lawyer's choice. But the second question, whether the lawyer can concede that, is a question that comes up again and again, as shown by Alvarez in this case and others. And the lawyer here said, that's my decision to make. If it's not his decision to make...
Without an affirmative response from your client saying, no, you can't do that, is that squarely before us?
The rule of law is squarely before you, whether whose choice it is to make. And the people argue again and again in their briefs that it's the lawyer's choice to make. Guidance is really needed on this issue.
Thank you, counsel. Thank you both.
Thank you.
Thank you. You know what? This one I think is not going to